Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today we have a very important update on the Ripple v SEC lawsuit. The judge just came out with a couple of conclusions, and even though it is very freaking confusing, I think we have a good estimate of what just came out, and it's very freaking interesting, guys. So make sure that you press that like button if you're enjoying the Swift updates. I tried to live stream it, but as about 100 of you guys noticed, it just wasn't working. I don't know. My internet is extremely good right now, but the stream just wouldn't load for some reason. Not a technical specialist like that. I don't know what the problem was, but make sure you have your notification bell on for all future updates. And I got to quickly put in these timestamps to make sure I can put them in the description for you guys. It's a lot of work, all right? But a lot of you guys say keep it going, so I'm going to keep it going. All right, this just came out on Crypto Law. Just added to our document library. Order from Judge Netburn on 2 motions, 1 set each from defendants and from the SEC. So, Netburn ordered the SEC to answer Ripple's interrogatory and identify the specific terms of the investment contract from XRP sales, and to answer whether the SEC contends that Ripple's efforts are necessary to effect any increase in XRP price. All right, let's back this down, or how do you say it? Let's break this down. There we go. Netburn is the judge ordered the SEC to answer Ripple's interrogatories. Interrogatories are basically just Ripple and both sides asking each other questions about basically the primary objective of this case and what everything is about. So let's say one of Ripple's questions being, do you state that, literally one of the examples here, or for example, what part of our contract constitutes as an investment contract? Or do you state that we actually gave an investment contract, or something along the lines of, do you contend that Ripple's efforts are needed to make the XP price go up? All those types of questions are necessary to kind of get a baseline for what the question is about the entire lawsuit, like what's being discussed. And the 2 things here are, again, my examples weren't too amazing because I took them from the literal case here. So number 1 that the SEC has to answer right now of an entire list of questions is, what parts of Ripple sales of XRP actually constitute as investment contracts? Ripple basically stated towards the SEC, hey, we noticed you probably didn't even read our contract because we are asking you questions about them, and you're saying that they're not relevant to some degree, or that it would be unduly burdensome for you to go over all this content, which are a lot of contracts from Ripple's side. And Ripple concluded that they probably didn't read them, and so now they're asking questions about the contracts. And number 2 was basically the SEC now is to say whether or not Ripple's efforts are needed for the XP price to move in some way, shape, or form. That's actually a really important question here, because if the SEC says no, we can already kind of guess, right, where Ripple's going to head with that. Ripple can now argue that the SEC themselves said Ripple is not the main factor of the XP price, or at least not the only factor, like they kind of tried to claim before. They tried to kind of claim that Ripple is the only thing what's making XRP pop, but they're going to have to admit that the market, Bitcoin and whatnot, has some effect on it too, which Ripple can most likely magnify a little bit, saying, no, we disagree. We think the majority of the movement is actually, according to Bitcoin. Because think about it, the SEC is going to have to back up every single time that the XP price purely moved because of Ripple, but more importantly, that Ripple is the only factor for the price movement, which is just impossible. And that's a nice little basis to have. It's not going to be the key to make them win, but it's a nice basis. The judge also grants most of defendants' motions to compel answers on other interrogatories. So, again, there was a whole freaking list of interrogatories. I don't know exactly how many there were, but a ton of them. Except for number 5, which specifically came from Chris Larson. That was a motion from Chris Larson on when the XP ledger was fully functional. So Chris Larson, I believe Brad Garlinghouse has 2, but we don't really know too much about that. The motion specifically here was from Chris Larson and Ripple. And Chris Larson's side was asking, for example, in literal terms here, when, SEC, do you think or constitute that the XRP ledger was fully functional? And this question mostly refers to the Ethereum debacle, where they say, Well, Ethereum at one point or another was fully functional, and so if we negate the sale that it had, it's now not a security. And so Chris Larsen was trying to ask, when was the XP ledger fully functional? Because from that point forward, theoretically speaking, it might not have to be a security anymore, or they cannot argue anymore that the XP ledger is currently still being built and thus still being a security. Like, for example, where Ethereum right now is still being built too, and so it should kind of still be a security. Except for number 5, Chris Larsen when the XP ledger was fully functional, which is denied without prejudice for being too vague, and the parties are ordered to confer to clarify the terms. So this basically means it's not completely denied, but they're going to have to go and talk about it a little bit more because it's a pretty open question, which I understand from some perspective. NetBurn grants some and denies some of the SEC's motion for protective orders, notably granting protection on defendants to 28,849 requests for admissions, writing, "It is hard to view this stunt as anything more than theater." Okay, so this one is the most fun out of everything. Basically, Ripple had about 30,000 questions for the SEC, split up into 6 different sections. The SEC tried to relieve themselves from at least 3 of the 6 sections, and section number 6 having about 28,000 of the 30,000 questions. And I believe the judge was like, what's going on here? All right, so she basically denied number 6, which has the majority of the questions, but the other 5 were granted, as I know from the conclusion somewhere at the bottom. But I think usually there's a conclusion at the top and a conclusion at the bottom. So let's quickly read. This order addresses 2 pending motions. First, defendant Ripple and Chris Larsen move to compel. And by the way, guys, quickly, make sure you press that like button if you're enjoying these things, and make sure you press the notification bell on with that little subscribe button attached, I guess. First, defendants Ripple and Chris Larsen move to compel the SEC to supplement its response to 11 of Ripple's interrogatories and 2 of Larsen's. Second, the SEC moves for a protective order to relieve it of the obligation to respond to 29.9 thousand separate requests for admission. Because the discovery sought overlaps in certain respects, these applications are resolved together. Both motions are granted in part and denied in part. This last part here, actually, because the discovery sought to overlap in certain respects, this actually refers to one of the defenses that the SEC made. I feel like a freaking lawyer, guys, the way I'm talking about this stuff right now. I've been so involved in this Ripple v. SEC lawsuit. I know too much, man. Guys, if I don't upload for more than a week, you already know someone, come look for me, all right? Come look for me. Some places, some people know where I stay. Come look for me, guys. No, but this part refers to basically one of the smaller parts that the SEC had in their defense, where they basically stated that right now in expert discovery, some of Ripple's experts are basically inquiring the SEC about some of their contracts anyway. So since a lot of these 29,000 questions were about Ripple's contracts, they're saying it's kind of stupid to answer the questions in a double manner. And so the judge kind of agreed with that. And this first part here is basically bringing up the motions at the start. And again, then concluding that parts of what they were requesting, parts of these 11 interrogatories and 2 interrogatories was granted. And also part of the SEC basically trying to protect themselves is also been granted. So it's partially good, partially bad, but it's some big conclusions from the judge. The SEC brings claims against defendants under Section 5 of the Securities Act of 1933 for the offer of sales of unregistered securities, and the SEC alleges that defendants' transactions in XRP were investment contracts under the Howey test. The defendant's discovery request seeks information regarding the SEC's theories of liability and in further support of their defenses, including a fair notice defense and an extraterritorial defense. All right, so you can read a little bit more into this if you want to. I don't think it's completely necessary. The conclusion is all the way at the bottom. However, there's also in parts saying, for example, oh, number 19 has been granted. Number 17 has been this, that, this, that. Then again, I think some lawyer like Jeremy Hogan or maybe even John Deaton will come out here in a couple of hours, most likely, giving us the complete rundown of why every single thing being granted or denied is good or bad. So since I'm not even a lawyer, not a financial advisor, not a legal advisor, I'm not going to attempt that and spend another hour investigating everything. I'll just take it as, right, a couple of things that Ripple was looking for have been granted. I'm not sure exactly how huge it is just quite yet, but I'm happy with it. And a couple of defenses that the SEC put up have been granted too, which is not too crazy because, again, there are thousands upon thousands upon thousands of things that Ripple wanted. And already right now, there's been multiple sets that have still been basically confirmed that the SEC has to answer to, which is still thousands of questions. So I'm not really too amazed, I guess, or too sad or whatever. Here you can see that a lot of these things in the set, for example, have been ordered to be authenticated, or that, it's all reasonable, basically, the judge said, except for the biggest one, which is somewhere at the bottom. Here, a protective order has been granted for about like 28.8 thousand different requests, which again, I understand completely. It's pretty funny, but ultimately I understand. All right, so in the protective part, protective order being denied is a bad thing for Ripple because, I guess it's a good thing for Ripple. That basically means the SEC cannot protect themselves from answering, and it being granted is negative for Ripple because that basically means the SEC won on a certain part. Ordered being in big just basically means the conclusion. Again, denied being good, granted being bad, but it's only one granted, and that's for number 6. 4 and 5, they have to answer right now. And I'm not exactly sure why, but look at this. Lastly, the 6th set of requests returns us to the disputed issue of whether defendants' sales of XP constitute as investment contracts under Howey. Defendants asked the SEC to constitute over 1,500 contracts and answer 13 preliminary questions. Unless an unqualified admission is provided, which the SEC represents it cannot do, the SEC must respond to subsequent 28,849 requests. And despite the defendant's protestations that this volume of requests is reasonable and will narrow the issues for trial, it is hard to view this stunt as anything more than theater. So the judge is basically laughing at Ripple for trying this, which is not so nice, but I'm not really sure, I guess, why Ripple put up this much stuff. Again, guys, I don't know if this is reasonable or not. I have no idea how it usually works in these lawsuits. I mean, it's pretty crazy, and then again, it's also not because it's a $1.4 billion lawsuit. So I mean, yeah. And in conclusion, to end it off, defendant's motion to compel is granted as to Ripple interrogatory number 2 and 11, and denied without prejudice as to Larson's number 5. As to the rest of the interrogatories at issue, defendant's motion is granted insofar as to the SEC. As the SEC is ordered to supplement any responses that are unverified because they incorporate or refer to unverified statements. So this basically means the SEC has to back some stuff up, which Ripple didn't find clear, and to supplement any responses that incorporate by reference its responses to other interrogatories. This basically means the SEC has to clear up every single part where they just refer to another answer they gave. Ripple, in one of their replies or one of their, I guess, complaints, said, SEC, what you're basically doing is answering one question with the answer of another question, even though they're not the same. So don't do that. That's again what the judge ordered. In accordance with Rule 33B, 3, and the SEC's motion for a protective order is granted as to the 6th set of requests and denied for the 4th and 5th, unless otherwise provided in this order. SEC must respond to these discovery demands within 45 days, which is nice. And the clerk of the court is respectfully requested in grant in part and in part deny the motions number 326 and 367. So ordered by Judge Sarah Knepper. Nice. Right, nice. Give you guys the update, give you guys the rundown. Hopefully you all enjoyed this. All right, I thought I would have to put in a couple more timestamps to get some stuff jiggling, but it was actually pretty damn simple, I guess, huh? Conclusion, this is pretty nice for Ripple, pretty nice for any XP holder here. As a matter of fact, the SEC has to answer and clarify a lot of things right now, so that's juicy. Tomorrow, there will be another lawsuit update coming out because I think it's the 22nd. Yes, the 22nd, we have a couple more things coming out here. One of Ripple's responses has to be given out tomorrow, so there'll be some bigger updates or some crazier stuff happening. I'll update you guys as stuff comes out, though. Make sure you subscribe for that, guys. You want to be notified every single time something happens in this lawsuit because one day, everything could suddenly switch over. And of course, I provide a lot of other crypto news too that you might want to check out. Take care, everybody, and have a very, very nice day.